All right, well, we'll call the meeting to order, and I guess first order of business, I'll turn it over to Professor Mystic for a discussion regarding the deputy director position, which we are seeking to fill.
Thank you, Mr. Chairman. When this meeting was originally advertised, it included a notice that the commission would be going into executive session to discuss a personnel matter. For administrative purposes only, that is no longer necessary at this time. However, pursuant to the open meeting law, there will be a future executive session required at some point before the next quarterly meeting. And of course, any recommendation that comes from that executive session, which will involve a personnel matter exclusively, will be voted upon at the next regularly scheduled quarterly meeting, which is a public meeting.
All right. Thank you very much for that. We appreciate the notification. I guess at this point, Mark, I don't know if you want, how do you want me to proceed? Do you want me to turn it over to you? Do you want me to turn it over to Judge Bernstein? I know this is formally a commission meeting, although it seems like it's more a policy discussion than.
Sure. Let me just maybe provide Judge Bernstein with a minute to kick things off, and then I can take it from there.
Perfect. Judge, the floor is yours.
Good morning. We have a special session where this is a work session to evaluate and review the sentencing guideline proposals. I know there's a tremendous amount of material that we all receive, but generally speaking, our executive director is wonderful at breaking things down and to bite-sized pieces so we can all digest it. So I think that's what we're going to start with, and then I'm assuming looking for some feedback and interaction. So I'll turn it over to the executive director to get us started. Thank you.
Great. Thank you, Judge. And good morning, everyone. Just a reminder that this meeting is being recorded. It's available via Zoom, of course, and it's being live streamed. With that, let me just note there are 4 documents that were provided to the members and are posted on our website for this meeting. One of the documents is, well, several of the documents were provided to members during the June commission meeting, and the one that was labeled highlights of public comments is a document that provided the feedback from the 6 public hearings we had earlier this year on the working draft proposals for the guidelines. And it also included a revised matrix, a matrix that included 5 prior record score categories 0 through 4, and included 30 OGS categories and 6 homicide categories. So that document was provided to the members, and we discussed it briefly during the June commission meeting. Since then, I've had the opportunity to meet with DA Sunday and then with the DA's Association. Ryan and I had an opportunity to meet with a gathering of public defenders. Later today, I'll be meeting with the Pennsylvania trial judges with the criminal section to discuss the proposals to date. And I'm also working with the Office of Victim Advocate to schedule a meeting with victims of crime to discuss guidelines and proposals. And then Ryan has been working on scheduling several regional meetings. We have 2 scheduled so far that involve numerous counties, and I think there's 2 others that are sort of in the planning stages. So we see this as just a continuation of getting feedback regarding those initial proposals that were published and for which we had public hearings, and really to continue to move the commission towards drafting new sentencing guidelines, the 8th edition sentencing guidelines, and starting to move that process forward. So, the one document that I provided was those highlights that you've seen before, and then there were 3 other documents. One of them was a comparison of sentencing guidelines, current working draft, and revisions. So it was an effort to think about some of the major proposals that are before the commission in terms of offense gravity scores and prior record score policies and details of that, and then the matrix itself, and to try to sort of show what the current guidelines provide, what we provided in those proposals that were published in January and for which we had public hearings, and then some revisions that staff had developed in response to public hearings and provided during the June commission meeting. So that's a document that sort of provides some details, but hits on those key points. And then along with that was a document that provided numerous sentencing guideline matrices. So the first was the current guidelines, so the 7th edition, Amendment 6 guidelines. And with that were the deadly weapon enhancement guidelines, because we have separate guidelines for those. So those were included. Then I included the matrix that was published in January and for which we had public hearings that had 36 OGS categories plus 6 homicide categories. And then we had the most recent revision to that, which, as I mentioned earlier, has 30 OGS categories and 6 homicide categories. The final document that, if you were up late last night, you received, but otherwise you received in your mailbox early this morning, was a first attempt at drafting the sentencing guidelines. And really what it is it's a markup of the current the text of the current sentencing guidelines. So this document takes the text of the 7th edition Amendment 6 guidelines, and then just highlights areas that would change if the proposals were adopted or implemented as new guidelines. And so some of these are sort of tedious things and sort of delete areas that we don't need. But I think it also is a sort of a systematic way to look at some of the issues we've been talking about sort of in context. And I think that might be the easiest way to review things this morning, because what we're trying to do, or what we hope to do this morning in a 2-hour period of time, we're going to finish by 11, is to just sort of walk through those and try to get a sense of where the commission members are in terms of trying to move towards approving draft guidelines for public hearings. And so there's a number of things we've discussed in a lot of detail in terms of OGS assignments and prior record score policies, lapsing policies, how to deal with enhancements, how to deal with adjustments to guidelines. And we got a lot of feedback on that, some very positive feedback, some pretty critical feedback, but I think we keep moving the ball. And so I think we're advancing in terms of trying to incorporate those comments we heard and bringing back drafts to you for consideration. So that's what I'll try to do this morning is walk through this document, this draft proposals, the markup document. But I think it may be helpful that we can reference those other documents that I mentioned, the one that has the comparison of the current working draft and revisions, and the one that has the most recent matrix, because I think those are going to be the key things that we look at. So as a start, just as a reminder, we've been working on these revisions since 2014. And the idea was to take a fresh look at the guidelines, look at what other jurisdictions do with sentencing guidelines, look at the provisions of the new model penal code related to sentencing, listen to feedback from participants, use a lot of working groups to try to figure out what should be changed and what should remain the same. A real effort on streamlining and automating the process. And so in conjunction with rebuilding these sentencing guidelines, we are also rebuilding SGS Web, which is our JNet-based application that's used to generate the guidelines and to have courts report sentences to the commission. So we've been in that process for a while now. By November, we hope to have the sort of architectural blueprint for us to move forward with actually going in and rebuilding sections. And we anticipate that the sentencing guidelines section of SGS Web, the new and rebuilt section, will be built around the 8th edition guidelines. And it's all about trying to automate processes to make it easier for users to consume information from other sources like the courts and for parole guidelines, the Department of Corrections. So we think this could be really helpful to end users and improve the accuracy and completeness of commission data. So a lot of moving parts, but I think a key to this is moving forward on guidelines that allow us to automate and also to promote maybe better policies. So with that, I'm going to start with the document. That's the markup. I'm going to ask Ryan to screen share that, and I'd encourage you to look at that. And if at any time you have questions or comments or want a little more detail, again, keep in hand those other documents. We can screen share those as well, but I think we can use that to sort of dig down deep into some of these issues. So unless there's any comments to start, I'll move with this first page of the draft document. And I'm going to focus on just anything that's highlighted, make a quick comment, and move on until we get to the really detailed things. So on the first page, the only comment here is related to the timing of the guidelines. I think at this point, we're thinking in terms of new guidelines effective January 1st of 2024. So the idea would be that, later this year, either September or December, the commission is in a position to approve draft 8th edition guidelines to publish for public comment, that we hold public hearings, hopefully early next year at the latest. And based on that, move towards the adoption of the guidelines in the first half of next year. That would allow time for us to submit it to the General Assembly for review, but it would also provide time for implementation, because this is a real rebuilding of the sentencing guidelines if we move in the direction that's recommended here. And so there's going to be a meaningful amount of time necessary to provide the education and outreach related to the new guidelines. And as I said, we're rebuilding SGS Web, and we anticipate that the new SGS Web, especially related to the sentencing guidelines, would be available for January 1st of 2024. So at least at this point, that's the target date for the new guidelines. And you'll recall that for sentencing guidelines, they apply to offenses. They apply based on the date of the offense, so they're prospective. So for guidelines that are effective January 1st, 2024, they only apply to offenses committed on or after that date. And so the guidelines actually would start to be in use later in that year, usually several months after the effective date. Unless there's any comments or questions on that, we'll move to the next page. And the first sort of key area here is the offense gravity score section. So as context, and again, you might want to refer to the matrix, but you'll recall that under the current guidelines, the general matrix has 14 offense gravity score categories. And then we have OGS 15, which is for murder 1 and murder 2. Under the revised or the proposals that we have, and the revisions to those proposals that you have in your hand, there would be 30 standard OGS categories, and there would be 6 of those homicide categories for murder 1 and murder 2. So let me talk a little bit about the change in terms of going from let's say 15 OGS categories up to 36 standard categories down to 30 standard categories. One of the reasons there are more categories is that there was an interest during the entire review period to have more focused guidelines that focus first on the disposition, so probation versus jail versus prison, and then the duration. And the idea of being much more targeted was promoted by the Justice Reinvestment Initiative and by many people that we heard from. But in terms of providing targeting, it was also helpful to have sort of tighter ranges and more of them so that we could be more discriminating in the assignment of offenses to those OGS categories. So we're just trying to be a little bit more targeted with the sentence recommendations. And in order to do that, we just needed more categories to work from. This substantially changes some of the things about our current guidelines. Our current guidelines tend to include multiple dispositions like restorative sanctions, probation, and county jail, all being in the standard range. And with the aggravated and mitigated terms, you could have a circumstance where someone under the guidelines, under one of the ranges of the guidelines, could get guilt without further penalty or state prison, and they'd both be considered sentences within the guidelines. So the idea here was to have more and more discrete OGS categories so that there would be an initial target on a specific type of disposition and then the duration of that. So that's what we're moving towards here. The other thing is this rearrangement helps to have more regular step-ups as you're moving through the different types of dispositions. So for restorative sanctions or probation or county jail or state prison, the sort of the movement from one OGS to the next is more regular. And so we can use that kind of structure to build in things like enhancements or adjustments to guidelines where we say, add two OGSs, and that might be the way that you handle it, things like enhancements. And so that helps us to automate the guidelines as well. So we'll talk about this in more detail, but the big takeaway from this section is that we are increasing the number of offense gravity scores, and we're having much more targeted recommendations for each of the offense gravity scores. The one point that's highlighted below that is related to inchoate offenses, attempt, solicitation, and conspiracy. We received some pushback in public comments about the idea that inchoates would be assigned 1 point less than completed offenses. But it's important to note that that's our policy right now. We have a policy in place that says if the inchoate is to a felony 1 offense, the OGS assignment is 1 point less than the completed offense. So this just incorporates an existing policy that's been in place for a long time. That policy goes back to a point where the statute provided that inchoates to felony 1s were felony 2s. And so the commission dropped the OGS by 1 point because of that. When the General Assembly changed that statute and increased the grading for inchoates to felony 1s to felony 1s, the commission decided to retain the 1 point reduction in the OGS. And so that's retained in this set of guidelines. One thing I'll note is because there's more of these OGS categories and there's like less distance between each of them, a 1 point reduction in an inchoate is less than it would be right now. So the recommendation is lower than a completed offense, but about half of what it would be under the current guidelines. So that takes into account that although these are incomplete offenses and different in terms of maybe culpability or other things like that, they do share the same grade as the completed offense. And I think that's important to note, because when we get to talking about ethnic intimidation or terrorism or other things like that, where the offense is 1 point is 1 grade higher than the object offense, we talk there about a 2-step increase, because you're not only saying that there's greater culpability, but you're also increasing the grade of the offense. So unless there's any comments or questions, we'll continue to move forward. So some of these things, just deleting information that no longer applies because of these new rules. At D, you'll see the ethnic intimidation. And this is where under the current policy, it's a 1-point increase. But under the proposal and under the revisions to the proposals, we recommend a 2-step increase. Again, because there's more steps, 2 steps effectively equal 1 current step. So this is sort of the equivalent of what we have in place. But this also takes into account that in every case, ethnic intimidation is 1 classification, 1 degree higher in grade by operation of statute. And so the idea of having this as a 2-step increase versus inchoates being a 1-step decrease is a reflection in part that there's a difference in the grade as well. In this section of the guidelines, and this seems like sort of a tedious thing, but when this text was written initially, ethnic intimidation was the only statute that worked like this. The way it works is if someone is charged with ethnic intimidation, it's ethnic intimidation to an object offense. So at trial, you're proving both the object offense, the underlying offense, and ethnic intimidation to that offense. And upon conviction, ethnic intimidation takes a classification 1 higher than the object offense. And effectively, the object offense merges into ethnic intimidation to the object offense. So at the time that ethnic intimidation was created, this was sort of a novel approach, and there weren't other offenses like that. So we in the text of the guidelines sort of separated it out to explain it and to explain the OGS assignment. Since then, there have been other offenses that follow that same model. Certainly terrorism and eco-terrorism are written that way. And there may be others that I'm just not thinking of offhand. So we thought it would be helpful in the new guidelines to expand this definition to capture not just ethnic intimidation, but other offenses where the subsequent conviction is 1 grade higher than the underlying offense. Moving to the next section, which is the violation of the Controlled Substance Act. The one provision here that's different under the proposal and the revisions is that we create a new category of drug offenses that take into account the doubling of the statutory max. So there are a number of drug felonies where if there's a second or subsequent offense, the statutory max is doubled. And this also applies in certain cases when there's delivery to minors. The statutory max doubles. So the commission has proposed that for those offenses, when the statutory max doubles, the commission will create a higher offense gravity score for that second or subsequent, or that offense involving distribution to minors, which reflects the higher grading of the offense. This is consistent with other parts of the statute where the General Assembly has created an escalation of the grade of an offense because of a second or subsequent offense. And the commission has generally provided higher OGS assignments for those. So this is just treating drug felonies in a manner similar to those other second and subsequent offenses. Unless there's any questions on any of that, I'll keep moving forward. So this might be helpful to refer to one of those other handouts you have, and it's actually page 1 of the comparison of the current working draft and revisions to the guidelines. This deals with the omnibus offense gravity score. So as you may recall, the omnibus OGS is the default OGS assignment. The commission goes to great lengths to give individual OGS assignments to every offense and a lot of subcategories of offenses. But if the General Assembly were to create a new offense, the commission needs to have a policy in place to allow for the OGS assignment of that offense absent action by the commission. So we need a default in place for new offenses or changed offenses by the General Assembly. And so these are the defaults we put in place. And under the current guidelines, you'll see the defaults there for felony 1 when the max is greater than 20 years, and then felony 1, felony 2, felony 3, and then for unclassified felonies, and the same at the misdemeanor level. And what we tried to do as staff was look at what the sentence range was for those default assignments. And as part of the proposal and then part of the revisions, we tried to identify the new OGSs that would sort of match to that. And so in the first page of the comparison, you'll see not only the OGS assignments under the current guidelines and the range of, oh yeah, there we go. Thanks, Ryan. So you'll see on this table, the top one is the current guidelines, and you'll see the OGS value, like OGS 10 for the top one. And then you'll see the standard range recommendation for a 0 prior record score. And if you go down to the next category, you'll see this was the working draft. So this is the proposal we published in January and had public hearings. So that sort of used the 36-point OGS scale, non-homicide OGS scale, and gave OGS assignments and then the standard range 0 prior record score for those, so that you could compare the current to the proposed. And then the revisions at the bottom are adjustments because now we have 30 non-homicide OGS ranges instead of 36. So we had to do some adjustment there. And so we put this out. One thing of note, I think, is for what we call the super felony category, the felony 1 where the statutory max is greater than 20 years, you'll see that recommendation is higher than it is under the current guidelines, because there was a sense that OGS assignment was very low as a default, given the seriousness of those offenses. But otherwise, we tried to make sure that we were sort of in the same zone as the current OGS assignments. So unless there's any questions or comments regarding the OGS assignments, again, that's the default, and that would be in place. That gives you a sense of the scaling of the offense gravity scores. Great. We'll continue to move through. I'm sorry this is like a monologue, but I guess it's the nature of the beast. So at G, and this is page 3. Page 4. Make sure I have the right page. Yeah, that's on page 4 of your handout. At G, this is just a replacement of text. Under the current guidelines, we have an OGS 15, a separate matrix just for murder 1 and murder 2. It has effectively 6 categories. So remember, for murder 1 and 2, we have the 2 age categories for effectively 10 to less than 15 years of age, 15 to less than 18 years of age, and then 18 years of age or older. And we have that for murder 1 and for murder 2. And so the baseline for any of these recommendations are the mandatory minimums that exist. And then the commission is built into the guideline matrix increases due to prior convictions, the prior record score. So this would just swap that out as part of the new guidelines. That really completes the discussion of the offense gravity scores, except for when we go and look at the matrix itself. But at this point, I think that's the relatively minor changes in terms of text, but some pretty big changes in terms of the number of OGS categories. So seeing no questions or comments, I'm going to move on to the prior record score. Now, this is complicated, right? There's a lot of moving parts. So this might be, I think this is where this approach of going through the text might be the most helpful. So but I encourage you to ask questions along the way or make comments. So the starting point is, and maybe if you look at the sentencing matrix as a side document, this will help you to visualize it. But on the current sentencing guidelines, we have 8 prior record score categories: 0 through 5, RFEL, and REVOC. And it's sort of a complicated approach. And I see Judge Bernstein's hand is raised, so let me take a pause.
I'm so sorry. I was trying to figure out how to raise my hand before you hit prior record score.
No problem.
The only question I have is because if someone asks me, I don't know the answer to it. On the omnibus, the felony 1, you explained the super felonies why there's a big jump because of the serious nature of the offenses. And also, I just noted everything else seemed pretty lined up except for the other felony 1. It just went from a 9 to 16 to 16 to 22. I just wanted, I'm sure there's a good explanation, but can you just explain that? So if somebody asks me about it, I know it keeps it up in the state. And I didn't know if that also fell in line with what you did in terms of number crunching for what sentences looked like to be more consistent with what's currently happening. So if you could explain that very briefly.
Sure, Judge. That's a great question. I appreciate it. And I should have mentioned something. As you look at this, you'll see that for felony 1 under the current guidelines, it's 9 to 16, which under our current system would allow for a county jail sentence or a state prison sentence. And under the proposed guidelines, we use the anchor of 16 months, but use 16 to 20. So it's higher, but it has that overlap at 16. So keep in mind, because of the new structure of the guidelines are either going to recommend a county jail sentence or a state prison sentence. So based on what we saw as the sort of the felony 1 sentences that fit that category and where the typical felony 1 sentence would be recommended in the guidelines, it would be in state prison and it would be at a higher amount. So it would be at 16 months or higher. We were trying to think in terms of proportionality about where we would build these defaults, these omnibuses into the guidelines. And based on the sentences being imposed by courts for felony 1 offenses generally, and then looking at the distribution of those assignments on that new OGS scale, what we found was that the current OGS assignment for a felony 1 was relatively low as compared to what the sort of the lower reach of typical felony 1 offenses were. So we decided that we would use the 16 from the current range as part of the recommendation, but we would move up from there instead of moving down or finding a middle point, because it would better reflect what we see in sentences generally for felony 1 offenses, and it would provide sort of greater proportionality in terms of how sort of the ranking of offenses occurs under the new matrix. So any of these assignments, anything else, are subject to change if the commission determines that they feel another value is more appropriate. But these are based on sort of a review of the data we have on sentences for 3 years, 0 prior record score, and what we see is sort of the proportional spot to put a default for a felony 1 offense.
Thank you.
Sure. Thank you, Judge. So we're going to move back to the discussion of prior record score. And as I said, we're going to start with categories. And if you were to look at the current matrix, you would see that there's 8 categories. Under the proposed matrix, the working draft matrix that we put out in January as part of the public hearings, there were 4 categories: 0, low, medium, and high. And high included effectively both the RFL and REVOC categories that we have now. During the public hearings, we heard we heard a lot of comments about those categories, a lot of comments about prior record score, but particularly about those categories. One was a general concern, and I think we heard this from a lot of parties, that to some degree the changes in the prior record score policy were maybe a little bit more harsh or provided more serious recommendations for sort of the less serious offenders, and maybe provided greater leniency for more serious offenders. Just as a relative comparison, like the penalties or the recommendations for people with lower prior record scores seem to be a little bit higher than they would be under the current guidelines, and those for serious offenses and higher prior record scores relative to the current guidelines seem to be a bit lower. So there was that general concern. And then there was a concern that there was like a gap. There was like too big of a distance or a missing value between the medium and the high. A lot of people were ending up in medium, and maybe there needed to be another category that made medium a bit lower, and insert something between medium and high to get sort of that mid-range. So staff looked at that, tried to look at how the prior record score was developed, and what the point system was and things like that, and developed a middle category. There was also concern about the labeling, that there was concern by using the terms low, medium, and high, it might be conflated with a risk assessment or something like that. So the idea of moving back to a numerical value, 0, 1, 2, 3, and 4 was recognition of that concern. The other thing was, for each of the cells, each of the recommendations linked to a prior record score, there were concerns that that the recommendations were maybe too narrow, and maybe weren't a good fit in certain cases. So the idea of adding yet another category allowed us to look at the current guidelines and try to take into account some of the issues in terms of typical sentence and things like that, and coming up with these new prior record score categories that are a bit broader than we had in the proposal, but I think actually capture what we were talking about. The final thing with the prior record score is that through the work groups and other things that the commission had, there was this general interest in trying to reduce the impact of the prior record score. And the rule of thumb that was discussed was that the prior record score, generally speaking, should be no more than double the baseline recommendation. So if you look at a 0 prior record score, and then you look at 3 or 4 in the prior record score category, that highest category should be generally somewhere around double the baseline. So what staff did was try to look at that, and what we found was with the higher offense gravity scores, we were generally below the doubling, but especially in the middle of the guidelines, there were times that we were way higher. Under the current guidelines, we were 9 times higher in the highest category as compared to the lowest category. The proposal sought to really bring that back, and in some cases maybe went a little bit too far. So in the revisions we did, we tried to balance all of that so that we were closer to that doubling when you get to the highest category. Now, there's going to be some exceptions to that, and especially when you think about the REVOC category, where under the current guidelines, we allow the statutory max in all cases. and recognizing in that top category, that 4 under the new system, it would involve someone with 2 prior crimes of violence convictions. There are some times where that will be more than 2, but for the most part, the rule of thumb, I think, works better under this new proposal with these 4 prior record score category. I mean, these 5 prior record scores categories 0, 1, 2, 3, and 4 than under the previous ones. So that's the first issue. Just what are the categories we have? Now, where it starts getting complicated is how do you define those categories? And there's another table that might be helpful for you to look at. And in the handout, it was, I think, on page 4. So maybe Ryan can bring that up and we can look at that. There you go. Now in table 4, at the top of table 4, you'll see what we had in the working draft. And then below that, you'll see the revisions that we're recommending. So let me explain what how we even do the prior record score, because this is a substantial change. So yeah, if you could just, thank you, that's great. So if you think about our current prior record score policy, what the user has to do is first look back at every prior conviction and the judicial proceeding for that prior conviction. So let's assume the date of the offense is January 1st of this year. Well, we see as a policy that the only thing that counts in the prior record score are convictions prior to the date of the offense. So if January 1st of this year was the date of the offense, the only thing that would count in the prior record score is any conviction prior to January 1st of this year. And the way we figure out how many points you get is we look at each of the prior judicial proceedings, each of the prior sentencing hearings, and we identify the most serious offense in the sentencing hearing, and we give points to that offense. And then we say, if the court imposed a consecutive sentence on any of the other offenses in that judicial proceeding, we count that as well. So we give points to that offense. And so we have to do this, or whoever's preparing the guidelines has to do this for each and every prior judicial proceeding. And then we take all of those values, all of those offenses that have point values, and we determine the prior record score based on that. And we've come up with a scale that says, oh, crimes of violence are worth 4 points. So you get 4 points for that. And other, felony 1 offenses are worth 3 points, and so on. But it's a pretty complicated thing, and it's really tied into our guidelines, which makes it very difficult to automate because of all those factors involved. We have to look at each judicial proceeding. We have to look at whether an offense was imposed consecutively. The sentence for the offense was imposed consecutively. We have to know what the specifics of that offense are to figure out how many points it gets in the prior record score. And then we have basically a calculation about how that translates to each of the 8 categories of the prior record score to determine what your prior record score is. So this takes human intervention. It's hard to automate that. The other thing we found with our research was it doesn't do a very good job of predicting future crimes. So if prior record score is about, predicting future behavior, it's not great. And it mixes sort of apples and oranges. You could have a prior record score of 4 because you had a crime of violence like rape, or you could have a prior record score of 4 because you had 4 felony 3 offenses. So it blends together a lot of people, a lot of cases that really are quite different than one another. So the idea under the new proposal is not only to simplify it and not only to reduce the impact of prior record score, but to just focus on what many people said was the most important thing. We want to know what was the most serious offense this person was convicted of or adjudicated delinquent of. So we want to know the level of seriousness of this person's prior offending. And then we want to know if that was a single incident or if there were multiple incidences like that. So that's sort of the basis, the framing of trying to think about a new prior record score. Let's not try to figure out judicial proceeding and concurrent, consecutive, and all that other kind of stuff. Let's just look back at every conviction offense before the date of this offense. And let's identify the most serious offense. And it could be by the grade of the offense, but there may be special categories like crimes of violence that sort of would outrank that, would push that to the top. So if crimes of violence are the most serious, they'd be sort of at the top of the list in terms of ranking any prior conviction that you had before the commission of this offense. So you identify that most serious offense. And then the question was that a singular incident or were there other crimes of violence committed by this offender? Were there other, equally serious offenses this person was convicted of? So that's a totally different approach where we're saying how serious was prior offending and how often did that level of prior offending occur? And based on that, we say we'll assign a prior record score category. And we'll have categories that sort of focus on how serious was the offense and how often did that level of seriousness occur. So we wanted to link this to the grade of the offense when possible or some classifications of crime, because then we could automate it. And for purposes of people preparing guidelines, just as we do with the risk assessment, we could grab all of that information on prior convictions from the Common Pleas Case Management System. We could automate that. So the user starts with a prior record score based on all the information in the Common Pleas Case Management System. And then we would have an option for people to add additional information for things like out-of-state offenses or otherwise missing offenses. But once that information was in our system, then we'd make sure the next time this person comes before the court and someone's preparing the guidelines, we would bring up all of that information. So it would be embedded in a new prior record score. So I hope you can see that this would really automate the process that I think is the most difficult and time consuming with preparing guidelines would be automated, and it would be more of a review and an update as needed. So let me talk about how we use that information. So instead of the tedious way we have it in place now, we just look at any prior conviction or adjudication, we identify the most serious, and we identify the number of priors at that level. And this was what you see before you on the screen is what we had in the working draft proposal in January. And so we had these various categories. The top category was crimes of violence. Next category, felony 1 and felony 2s. Next category, F3s and ungraded felonies. Next category, M1. Final categories, M2 and less. So those were the sort of the 5 categories. And we said, and as you look across the top, if you had no offenses at all, then you're in the 0 prior record score category. That's pretty easy. But if you had 1 prior crime of violence, you're in the medium category. And if you had 2 or more, you're in the high category. When we looked at felony 1s and felony 2s, again, none of them, you'd have a 0, you'd be in the 0 category. If you had 1 of those, you'd be in the medium category. And if you had 2 or more, you'd be in the high category. But you might recall the high category was a combination of RFL and REVOC. So there was a separate recommendation for REVOC and one for RFL. So you can see that's how we would differentiate crimes of violence from other felony 1s and felony 2s. If you had an F3 or ungraded felony, if that was the most serious of all your prior offending, and you only had one of those, one at that level, you'd be in the medium category. But you'd remain in the medium category if you had more than that. So any number of F3s or ungraded felonies would put you in the medium category. And then you can see the rest. M1s would be low, and then medium, and less than M1. So M2s and less, you'd always remain in the low category. And that's not inconsistent with our current policy, where we basically cap people at an OGS 3, at a prior record score 3, for any number of those lesser misdemeanors. So this has some flavor of that. So let me show you what we've done in the revisions to address some of the comments and concerns we received. As I said, we added an additional category so that we had a little bit more, detail available. And we added a new category of offenses. And this was, we heard this from the AG's office, from many prosecutors. And in fact, even from the defense bar, we heard about the need to better separate out sort of nonviolent from violent offenders. And so one of the recommendations was, and a common theme that we heard, was a concern about 3 types of offenses that sometimes, even if the grading is relatively low, they're serious offending, and they could sort of, the grading may underestimate the seriousness of the offense. So the 3 that we heard about were offenses that involve danger to persons, offenses that involve firearms, and offenses that involve sexual behavior, so sexual offenses. So if you look at our list of offenses there, we still have crimes of violence as the highest, the most serious. Then we have the F1s and F2s, unless otherwise designated. And the next category you see are these serious offenses that we heard concerns about. So obviously they're F2s or less than F2s, because we have F1s and F2s in the upper category. But this would be Chapter B offenses. So if you are spending any time looking at Title 18 of the Crimes Code, or Title 18, the Crimes Code, you'll see that there's under the listing of offenses, Article B is the offenses involving danger to persons. And it's a pretty long list. It includes chapters 23 through 32. So homicide, crimes against unborn children, assault, anti-hazing, kidnapping, human trafficking, sexual offenses, and abortion. Those are the offenses within this chapter, or this article. And so what we did as a starting point was included that as one of the special categories for serious offenses that weren't felony 1s and felony 2s. We included Chapter 61, which is violations of the Uniform Firearms Act. And we included the Megan's Law offenses, the tiered offenses. And so that is in that special category as serious offenses. Then below that, we have the F3 or ungraded felony, unless otherwise designated. And then we have the misdemeanors, unless otherwise designated. And keep in mind, because we've removed those, what were considered serious misdemeanors or felony 3s into that category, that special category of serious offenders that we created, there's a little more flexibility for those lower categories to treat them less seriously. And that was one of the things that I think the defense bar raised as trying to make sure that we weren't putting too many people up in the medium category and pulling them down to a lower category because of prior offending that wasn't serious or violent. So under this sort of rebuilding, crime of violence, if you have one prior crime of violence you're in the prior record score 3 category. So remember, there's 5 categories: 0, 1, 2, 3, and 4. So a single crime of violence would put you in category 3. 2 or more crimes of violence would put you in category 4, and category 4 is really reserved for the old REVOC. Moving to felony 1 and felony 2, unless designated, 1 prior would put you in category 2, and 2 or more priors would put you in category 3. So category 4 is reserved for REVOC, for crimes of violence. This new category that we have is serious offenses that are less than felony 2s. At this point, we treat those like felony 1s and felony 2s. So, one of the discussions we had with the public defenders about this category, and it was more about lapsing, but I think it's a general comment that we could look at, is should this special category that we've created for serious offenses be limited to felony 3s and unclassified felonies? Should we remove the misdemeanors from that? I think that might be inconsistent with what we heard about some misdemeanor offenses that are less serious, but maybe we could think about it in terms of M2s or M3s. But I just sort of throw that out for future discussion. If you continue down, then when you get to the felony 3 or ungraded, and you've excluded those serious serious offenses from that category, you'll see that for 1 prior offense like that, you were in category 2, in prior record score category 2. You remain in that if you have 2 priors, and you move up to 3 if you have 3 or more priors. And then when we get down to the misdemeanors, any misdemeanors, 1, 2, or 3, or unclassified, that aren't otherwise designated as those serious offenses, for 1 prior, it's and any number of priors, you would be at 1 point. So you'd be effectively in that low category based on that. So we think this is clearly different. There's some discussion around that special category and how broad or narrow it should be. But we think this at least tries to respond to some of the concerns raised, both in terms of not treating seriously enough some of the serious offenses related to harm against persons and firearms and sex offenses. And it also provides, I think, more opportunities for those less serious priors to be treated in a lower category, a lower prior record score category. So I've rambled about a lot of this, but maybe this would be a good time to open it up for any comments or questions. Okay. If we can go back to the other table then. So we've just spent a lot of time talking about the prior record score. We talked first about the categories. So again, we're moving from the 8 categories to 5, and we relabeled them 0, 1, 2, 3, and 4. 4 is effectively the REVOC category we have now. 0 is a pure 0. There was a lot of talk about wanting a pure 0. And so 0 is that. It's no prior convictions, no prior adjudications, but it does take into account if you have a lapsed record, then you could be in the 0 category once a record is lapsed. But this, hopefully, so those are the categories. We talked about the streamlined way of counting offenses, that you just look at all prior offenses, identify the most serious, and determine the number of that level of seriousness. And then we just talked about how you would then move these individuals into categories, and how we have this additional category to accommodate sort of that mid-range one that people had concerns about. So that gives us sort of the framework that is similar in terms of policies to what we have now. You have prior record score categories, and you have a calculation of prior convictions and adjudications that gets you into that. So now what we want to do is we want to look at a couple of other rules that deal with what conviction offense count, and what prior juvenile adjudications count. So for the prior, Judge Bernstein.
Yeah, I'm sorry, it's me again. So this can be a brief answer, and maybe I'm just getting stuck on the word seriousness, but when we're talking, I'm gonna try and find the language. When we're talking about, let me click up to where we were. Prior record score categories, we're talking about equal seriousness. I thought there was something up before where you use that language, but what I'm hearing is it's not necessarily the grading. It's the grading, but it also could include the grading may not be as high as some other things, but the type of crime is going to take it to that higher level. Is that right?
Yeah, that's correct. And let me, go ahead.
My only question is going to be, is there going to be some section that defines what constitutes a quote unquote serious crime with a listing so people can turn to that easily to understand it?
Yes, in two ways. Number one, we can provide that. So the shorthand is, as we listed it, all of Article B, if the commission goes with that for, all misdemeanors, all felonies in Article B are captured there. They're not, crimes of violence or F1s, F2s. All of Chapter 61, so any VUFA, and then anything that's a sex offense under Megan's Law. So that's the sort of the cheat sheet version. We can provide a full list of all of those offenses. And in fact, we can do that for the September meeting because the commission may want to look at that and make decisions about whether you exclude, let's say, M3s or M2s from that full list. But that will be a decision of the commission. In terms of, and we can always publish that list of what those serious offenses are. But we can also, as I said, build this into SGS Web. So remember, what we're trying to do is automate the prior record score. So effectively, what would happen is, as someone's preparing a guideline form based on the conviction offense or the offense charge, so the OTN or the docket number that we have on that case, we are able to obtain electronically from AOPC all of the prior conviction information in their system. We can bring that into our application and we can actually filter through that and identify the most serious offense. And we can build into our system that list of serious offenses so that any of those show up, we know that, fits that category. But it's just the same way we have a list of crimes of violence based on statute. And if a crime of violence shows up in that list, it'll be flagged and we'll know that that person has at least one crime of violence. And if we see two or more, they'll be flagged as well. And we'll know that that person automatically is in prior record score 4 category. So I think you can see how this would automate the entire process. And then the user could just check the work to see if there's anything missing.
Thank you.
Sure, thank you. So for the prior record score for the adult side, a new provision that we recommended or was in the working draft in January was the idea of adult lapsing. So trying to figure out circumstances under which prior adult convictions are no longer considered in the calculation of the prior record score. So there are 2 different approaches to lapsing that are used by other jurisdictions. One approach to lapsing is what's called a decay. And you can think about our DUI policy where we have a 10-year look back period. It doesn't matter what happens during that 10-year look back period. After 10 years, that prior conviction does not count in the calculation of the mandatory or the grading of the offense. It goes away. So a decay is just after some fixed period of time, something is no longer considered. The other term used is gap, and gap is about law-abiding behavior. So setting sort of parameters and saying, if you've been law-abiding for this period of time, then that prior conviction will go away. So what has been recommended, and there's details about this, but let me just sort of focus on where the revised recommendation is. The first is that when we think about misdemeanor convictions, and maybe exclude from that misdemeanor convictions for those serious offenses that I talked about, the Article B and so forth. The idea is to have a decay so that at some period of time, just after a fixed period of time, those convictions are not considered in the prior record score. And the discussion or the initial recommendation that was included was a 15-year recommendation. In meeting with the public defenders, they encouraged the commission to think about a much shorter duration, especially recognizing that misdemeanor ones only go up to 5 years. So they thought that it may be more prudent for the commission to think about a decay period for misdemeanors of 5 years rather than 15. So I think the question or the issue for discussion will be, if there's going to be a decay and if it applies to misdemeanors, does it apply to all misdemeanors? Does it apply to only the misdemeanors that aren't in that serious category, like VUFA or sex offenses or Article B offenses? And what's the duration of that look back period? Is it 5 years? Is it 10 years? Is it 15 years? So that's one issue. If you're going to have a lapsing policy and you're going to include something for misdemeanor offenses, what about that? Second category is a gap category that focuses on felony convictions that are not those serious offenses that we talked about. So think about, a felony 3 offense would fall into this category. That's not one of those serious offenses we've identified. The idea here is that it's a gap. So you would need a 15-year crime-free period in order for that prior felony 3 conviction to go away, to not be included in the calculation of the prior record score. And then the final category that was recommended was a gap, again, crime-free for any remaining offenses. So this could be crimes of violence. This could be, any of those serious offenses we talked about. It could be other felony 1s and felony 2s. So this would be a 25-year crime-free period. Part of the discussions about crime-free was also, when do you start calculating it? And so, I think where the recommendation is right now is you need something that you can automate, and you need something that represents that if a person was in prison, that does not count as part of the gap period. But as many people know, it's very difficult to obtain and to verify and to automate information such as release on parole or other things like that might be difficult to consider. So, one option is to use the minimum term of confinement imposed by the court as the starting point for that gap period. But anyhow, there's other options there. Representative Stevens has his hand up.
Thanks, Mark. Along those lines, because I've been trying to give some thought to that issue of how do you automate that process. Is that because AOPC has all those dates, don't they? The release date and the recommitment date and things like that. Does AOPC or who?
Yeah, I'm not sure they do, and we can look at that because they've been incredibly helpful and they have a great system in place. But I'm not sure that that they have that release date. Now, the Department of Corrections / Parole Board does have that, but the issue of automating it is a little bit more difficult. And then remember that the offense might be from out of state. So we would need to have a policy in place if you were in New York State and had a sentence that, was subject to gap or decay. So, we have to think of something that, sort of structurally that maybe is not as dependent on a source of data, because otherwise, the other thing we talked about previously was there would have to be a burden on someone. So you could say, if it's about gap, the burden is on the defendant to provide proof to the court or information to document crime-free period. And, the court would make a determination, like other things at sentencing, based on preponderance of the evidence. The burden's on the Commonwealth to prove the prior record score, so the existence of the prior. So the proof of a gap or a decay would be on the defense. That was one of the discussions as a way to provide for this.
Just sticking with the automation piece, and maybe Judge Tucker or Judge Bernstein can help me here, but if I remember correctly, on an order, I guess it wouldn't deal with parole, but generally on a sentencing order, you're going to have the commitment dates laid out, right? So aren't those, those dates are being recorded. And honestly, from a public policy perspective, I feel like there should be that shouldn't be a black box that people can't unpack. You know what I mean? Somebody should be able to ascertain how long somebody was incarcerated and when.
Rep, there's no problem with getting the commitment date. That's not an issue. The issue is, when was the person first released, if we're talking parole? Because, and that's why I said one policy could be that you base it on the minimum term. Even if they're not released on that date, at least is data that we have in our system based on the minimum term imposed. The other option is the maximum term, but that would take into account, that would exclude from the time period any period on parole. And look, we're working with the parole board and the DOC on parole guidelines and recommitment ranges. So it is possible at some point we might find that there's really reliable data in state that we could use for that purpose. And then it's just we'd have to have a policy for how do you deal with out of state. But we're trying to figure out what's available right now that we could build into the process. And we have concerns about being able to automate the parole data. And it's even more difficult at the county level. But we'll talk to AOPC and others to see if there's reliable information electronically that we could use. But these were the concerns we were thinking about. Judge Tucker?
Yeah, Mark, are you saying that you will be including the period on parole as being part of that period of time of incarceration?
Well, that was one of the suggestions. One of the suggestions that we heard, one of the comments was use the maximum date as the starting point for considering a gap or decay period. And I think there was a lot of pushback on that, saying, hold it, the person's in the community under parole, that should be time at liberty that doesn't count, that is included in terms of crime-free time. The problem was, how do you identify a date consistently for all offenders that you'd be able to automate that starting time for a gap period or a decay period? That's where it was a little bit more difficult. But Judge, the sense was, if someone is sentenced today, if you sentence someone today to probation, they're on the street at liberty, and therefore the clock starts in terms of gap or decay.
So why couldn't we simply say, or maybe not simply, but why couldn't we say X amount of time after the date of release from incarceration or something along those lines?
Yeah, I think that's sort of where the policy is. The problem is we don't have a good source of data for knowing that parole date or that release date. So we'll check with AOPC, but at least the data we're working with right now, I'm not sure that's available in the message that we receive, but we'll look at that. Like I said, when we're working with the parole board and the DOC, they clearly have that information, but trying to make sure that we can readily get it to sort of use in this system. It's not about the release itself. It's about having a date that we can obtain and use in our system. So it's sort of technical in terms of information access to automate this. Judge Bernstein?
Thanks. I was just going to say, this sounds like one of the areas where we need to make a decision, and there's lots of considerations. So maybe for our September meeting, we could write down some of the proposals and bounce those around with the whole committee and see if we can come up with a decision on it.
Sounds great. Thank you.
Thank you.
And what I can do is I can follow up after this meeting to get something to members so that we can try to get a decision on that. And in the meantime, we'll investigate sources of data to see, where there are roadblocks or where there are possibilities. So thanks for the discussion. If there aren't any other comments or questions, we'll continue to move forward.
Mark, I'll just.
Oh, please. I'm sorry.
A thought. It seems like we would not be the first jurisdiction to do this. We can ascertain what other jurisdictions are doing and how they do it.
Yeah, we'll do that. That's a great idea, Judge. I know that in a couple of jurisdictions we talked to, Minnesota specifically, they do have some policies like this in place. They have, sort of a different structure because we're indeterminate. The date of release is sort of varied, whereas in some of those other jurisdictions, they're determinate. So it's much more, they can basically, prescribe pretty much based on the sentence when the person's going to be released. So it's, but we'll check. Maybe there's some indeterminate states that have a system in place, but that's good. Thank you. We'll check into that. Anyone else? All right, Ryan, if you could just move ahead. The next area is juvenile adjudications. And as I think we do have a lapsing provision in place for juvenile adjudications. It is effectively a gap policy, so the person has to be crime-free, and it also is really narrow. It's 18 to 28 years of age, crime-free. We remove everything but crimes of violence, and you either hit or miss on that one. So it's rarely in play. It's rarely used. And so the idea here was to come up with a policy that's a little bit, that is more generous and takes into account some of the research on brain development and other things about youthful offenders. The first thing I'll note is before we even get to lapsing, one of the comments we received from the Juvenile Court Judges Commission dealt with which juvenile adjudications we consider. Now always keep in mind that if a juvenile offender is certified to criminal court or is direct filed to criminal court and the case remains in criminal court, that's considered a conviction, and that is included in the prior record score, and it's treated like an adult conviction. So what the Juvenile Court Judges Commission was focused on was what about adjudications in juvenile court? And under our current policy, we start counting juvenile adjudications beginning at the individual's 14th year, so 14th birthday. And what we generally exclude are misdemeanors. So we focus on felonies. We include misdemeanor ones that involve death or injury, things like that. But we generally exclude misdemeanors. What the Juvenile Court Judges Commission suggested was the commission consider increasing the age of consideration of juvenile adjudications from 14 to 16. And so we'd only consider juvenile adjudication 16 years of age and older, effectively 16 and 17-year-olds. And then we also build in a lapsing policy. And as you'll see in the comment below, the categories for lapsing, the first would be at age 21, all felony 1 offenses, F3s or ungraded felonies, unless they're those serious offenses, the Article B, VUFA, and sex offenses, those would automatically be removed. So it would be a decay. So at age 21, those go away. At age 25, also a decay, would automatically remove any of the remaining offenses unless they were crimes of violence or felonies of Article B, VUFA, or sex offenses. So all misdemeanors would go away, even if they were in that special category. And so that would be misdemeanor 1s for juvenile adjudications. And then felonies that weren't in that category, that weren't crimes of violence or that special category. And then aside from that, so that's at age 25. Aside from that, the balance, any other kind of lapsing would be a gap. So a crime-free period for 10 years from the last adjudication or conviction. So you look at the last contact that person has with the juvenile or criminal justice system, and then you move 10 years ahead, and that would be the crime-free period in terms of all other juvenile adjudications being removed. So there's a lot there, but I think the first thing is about generally increasing from 14 to 16 the consideration of juvenile adjudications. I think this is consistent with some of the discussions, and I know Judge Tucker and others raised the concern about even considering juvenile adjudications because it's a separate court and it has a different purpose. So the JCJC said, recognizing that and other things, one helpful move would be to increase the age to 16. And recognizing if there were serious offenses under 16 that led to certification or direct file, those would be included as adult convictions. And then the other thing as far as lapsing was to have in place more straightforward policies about removing things at certain ages, and age 21 and 25 were the two ages listed. So let me pause and open it up for any kind of discussion or comments, questions. Okay, so what I'll do is when I'm providing information to all of you on the adult lapsing, I'll just reiterate some of this just to see if there's any comments or questions or concerns, because as is now, we'll start to move forward with including this in the prior record score, at least for your consideration in September. Okay, the next category, prior record score point scoring, effectively goes away because we are now just looking at the grade of the offense or the category the offender is in and the number of those. So all of this highlighted guideline point scoring information goes away. And there's a lot of it. So all of that goes away. So now we move to other miscellaneous provisions. We have sort of the removal of information on inchoates and ethnic intimidation, because again, that's linked to a point system, but now we're looking at the grade of the offense. So that is removed. It simplifies the process. With former Pennsylvania offenses or out-of-state offenses, again, just changing that to look at the grade of the offense or have defaults of an M3 if the grade isn't otherwise known, so that you have like a clear understanding of how we would handle those prior convictions if it's unclear. So that's just, modifying it so that we can automate it. And yeah, if you back up a minute, thank you. So, and then as far as excluded offenses, one of the things we need to look at, and staff just needs to spend some time looking at this, is little things like making sure we include whatever the new lapsing policies are in this excluded offense section, and then also looking at our policy regarding when we exclude an offense in the prior record score because it contributed to an elevation in the grade of the subsequent offense. We have an exclusion for DUI. We've now included a new category where we increase the OGS because of a second or subsequent drug felony. So we just need to look at this more closely, see if this policy still applies, how it applies. I will say that we had a lot of comments about the DUI OGS assignments and the DUI policy, and we have to look at that more closely. We generally default to the mandatory minimum provisions, but there were some issues raised by the DUI Association, by prosecutors and others, that we just have to look a little more closely at, and we will do that and come back with some thoughts about that at the September meeting. Moving through, let's see. So here's an issue that we won't decide today, but I think it's a starting point for a discussion. And we've talked about this before. Under our current guidelines, the way our guidelines work presently is that for each and every conviction offense, you identify the offense gravity score for that offense, you identify the prior record score for that offender, and the combination of the two are used to come up with a sentence recommendation for each and every offense. And although that seems like it was like carved in stone, prior to the 5th edition sentencing guidelines, the prior record score only applied to the most serious offense of a transaction. So when someone was in court for sentencing, generally speaking, the prior record score was applied to the most serious offense, and a 0 prior record score was applied to all other offenses being sentenced. At the time that we moved to the 5th edition guidelines and decided to apply the prior record score to each and every offense, the reasoning at the time was we were going to be moving from a transaction-based system where we tried to figure out how were offenses grouped together out in the community when they occurred, like incidences or something like that, which was always difficult to do, and move more to an offense-specific sentencing system. So for each and every offense, you had all the information about the offense and the offender, and you're making a decision solely on that offense. At that time, the commission also talked about having a companion policy in place that addressed concurrent versus consecutive sentencing, because the commission realized that by adding the prior record score to every offense, if there wasn't any type of measure to sort of address this, it would look like, I don't want to say double dipping, but clearly it would increase sentence recommendations because each and every sentence recommendation would be higher because the prior record score would now be added to it. So the commission discussed that, but in the end, the commission did not approve a policy related to concurrent consecutive sentencing. So since 1997, we've had a policy where prior record score applies to every offense, and we haven't had a policy about how offenses, multiple offenses, should be sentenced in terms of the aggregate sentence, concurrent consecutive. So I point this out here just to say that later on, when we're talking about these general recommendations, I put in the language that we talked about before from the model penal code, so that the commission can think about this or consider whether there should be anything in the guidelines about concurrent consecutive sentencing. So I think most of this other stuff you see is just textual. We're just like updating the text to take into account the new guidelines. So we'll just sort of move through this pretty quickly. In this section, yeah, we're just talking about how the enhancements work. So that's not a big issue. It's sort of, and here, yeah, just inserting some text. So some details about the sentencing alternatives, probation versus restorative sanctions versus county jail and state prison. We're suggesting removing the labels of P1, P2 because they wouldn't apply under the new guidelines. We now have probation ranges instead of this sort of abbreviation for 1 and 2 years. There we go. So here at the end of the general sentencing provisions is where if the commission thought it was appropriate, there would be a new policy related to concurrent and consecutive sentencing. So this is based on language in the model penal code sentencing, and it's adapted to sort of how we do sentencing with judicial proceedings. So the language would be, in a single judicial proceeding involving multiple convictions, concurrent sentences are recommended for lesser conviction offenses. Exceptions include convictions for crimes of violence, proceedings involving multiple victims, and offenses for which consecutive sentences are required by law. So let me just hit the three of those quickly. One thing that we heard about any kind of general policy about consecutive or concurrent sentencing was that we should carve out violent, serious offenses because courts should have all the discretion in the world of deciding concurrent consecutive sentencing for those very serious offenses. So crimes of violence would be that category that we identified. The second thing was that there was a real concern about, in a given incident or a sentencing proceeding, there may be multiple victims of crime, and courts generally want to have the discretion and need discretion to decide on what's appropriate when you have multiple victims. And so that would be an exception. And then the third one is there are provisions in statute, such as homicide by vehicle while DUI, which requires consecutive sentences for when there's multiple victims. And there's other statutes like that. So those are like exceptions that we think would have to be in there. But I hope you'd give some consideration to anything that the commission could do in a general policy way to say something about concurrent consecutive sentencing. Because I think, the guidelines are just a starting point. They're not the end point. And we do a lot with the guidelines to just promote a good starting point, but recognizing they're advisory and courts can exercise discretion. And this is one of those areas where we say nothing at all about concurrent consecutive. And as a result, you see a lot of disparity in sentencing where what appears to be similar cases become very different in terms of sentences because there's no guidance about concurrent consecutive. So I encourage you to just think about, maybe this language works, maybe it doesn't, but think about a policy that at least gives some guidance as a starting point to judges and to those negotiating pleas. So, any comments? Otherwise, we can we have about 10 or 15 minutes to go. All right, moving through then, some updates regarding the enhancements. And here's there's a lot of updates here, but here's the sort of the flow of this. Remember, under the current guidelines, we have effectively two types of enhancements. We have what we call general enhancements that can apply to any offense if this factor is present. So the most common one is deadly weapon enhancement. And we say, if you commit a crime and the possession or use of a deadly weapon is not an element of that crime, this enhancement must be considered by the court. So it increases the sentence recommendation if someone possesses a weapon during the commission of the crime or uses a weapon during the commission of the crime. And we have this as a separate matrix right now. So what we can do with this like new approach to sentencing guidelines is, for any time the court determines that this enhancement applies, it would just adjust the offense gravity score by 2 or 3 points. So if a person possessed a weapon, the court, based on that conviction offense, the court would check the box for possessed, and it would just add 2 points to the OGS and give the increased sentence recommendation based on that enhancement. If the person used the weapon, it would add 3 points instead. And for this and all other enhancements, effectively what would happen in the application is the court would have the conviction offense with the OGS assignment and the sentence recommendation. And then the court would just identify any enhancements that apply, in effect, a checklist. And based on that, the application would update the sentence recommendation. It would identify that conviction offense, it would identify the enhancements that applied, and it would provide the revised OGS and sentence recommendation, because it would be in effect a step-up system, because we have a more consistent scale for the OGSs. So that's how it works with deadly weapon enhancement. It works like that for other sort of broad or general enhancements like criminal gang involvement and things like that. So we have a bunch of those general enhancements, and that would be built into the guidelines in this way, just a point system. On the other hand, we have offense-specific enhancements, where the General Assembly has said, for this type of offense, when this factor is present, the commission shall provide an enhancement. So for those, for the most part, what we do is, back in the offense gravity score listing, we find that offense, we find what the OGS is, and we subcategorize it. We just create another instance of that offense, and we add in that sentencing factor, and we give it a revised OGS, a point or 2 higher, but we sort of build it into the process. So when a court is, when someone's preparing the guidelines, they're identifying the conviction offense with the enhancement. They're identifying that the enhancement was part of that provision. And so that's sort of locked into our list, where we have the list of all the offenses. And then there is actually a third category, which is like a hybrid of the two. We have certain offenses where the General Assembly has provided a whole lot of guidance on different things that should be considered for that offense at sentencing, enhancements that we have to consider. And while just dealing with one or two of those we could do by adding a new listing in the offense gravity score list, some of these are just pretty complicated. And so we sort of deal with them as a hybrid. We come up with some kind of special assignment based on certain categories, and then we say to the court at sentencing, if these other factors are present, add 1 or 2 or 3 points. So I just wanted to give you that as an overview of how enhancements work, because we went through this list of enhancements that we just updated with the last guidelines. And we just are swapping out basically directions to a matrix or other things like that, with like add 1 point, add 2 points, or look at the table back where we have all the offenses listed. We've taken care of it there. So So anyhow, not much new here, but if you're looking through this, this is where we trade off enhancements for just step ups on the matrix. And Ryan, if you could just sort of page down through this, there's going to be one section that I want to pause on, and I think you'll know it when you see it. So just keep going. So there's criminal gang enhancement. Third degree murder, we might want to move that right back to the table because it only has one factor as part of it. So it's like an offense specific one. So we'll probably move that back. Here's the one that I wanted to draw your attention to. The sexual abuse of children, so child pornography enhancement, is incredibly complicated. We have subcategorization back in the list of offenses, but we also have a bunch of other things we have to consider here. And when staff tried to map this enhancement as it works now to the new guidelines, it's just not an easy thing to do in terms of trying to be consistent with what recommendations the commission has. So I highlighted this because what staff will do between now and September is come up with a new recommendation for this enhancement that will be different than what we have now, but that adheres to the requirements of the statute, and we'll provide it to you for your consideration because we want to be able to automate this. We want to make sure we're honoring the requirements of the statute, and we want to make sure it reflects what the commission thinks is the appropriate penalties. But right now it's like way too complicated and we need to like rebuild this one. So I just highlighted it, say we'll bring something back to you at the September meeting related to this one. I'll also mention that I've been serving on the task force at PCCD that's dealing with this statute and this enhancement. And I hope to be able to, if there's any recommendations from that task force that relate to this enhancement, I'll incorporate that. But I will tell you that one of the things that's come out of those meetings of the task force is a concern, not only with this enhancement, but with other enhancements about how often enhancements are not considered by the court. And so through public education and through some other means, we're going to try to use the task force to try to promote greater consideration of the enhancements for these cases, and by turn, all enhancements, that courts give greater consideration to the enhancements we have in the guidelines. We found that when we were doing the VUPA study, we found that with the deadly weapon enhancement that it's underutilized. Not that courts can't sentence outside of the enhancement, but the enhancement isn't even applied when obviously it should have been applied. So we want to spend more time on this. And I think automating the guidelines will help in a big way. So this will just be part of that. These are just more enhancements. These are the offense-specific enhancements. So you'll find the specific values back in the offense gravity score list. And we'll move pretty quickly just to close things. In this section where we talk about sentencing levels, keep in mind that instead of the 5 sentencing levels, now we have levels that are A, B, C, D, E, F, G, H, I don't know. We have a lot of them because remember the levels now are linked to the disposition. So other restorative sanctions, probation, county jail, sort of a hybrid of county jail, state prison, and then state prison where the max is 20 years or greater, and then homicide. So, so those are the new levels that we'll put in place of this, and we'll have descriptions for each of those levels. So I just highlight the levels there. Yep. Modest changes to this. We did a lot of work during the last session, edition of the guidelines. So little things like replacing level 3 and 4 with level C and D about clinical assessments. And there we go. And finally, or almost finally, we have the section on aggravated and mitigated circumstances. So to sort of simplify some of this, we just reference the matrix because the matrix has the aggravated and mitigated duration or ranges on there. So we just refer to that. In the revised matrix, you can see that over on the far side. We also, in each of these cases, so A deals with aggravating circumstances. So we're talking about recommendations in the aggravated range. And then under B, it deals with mitigated circumstances. So recommendations in the mitigated range. And then under C, what we wanted to try to build into this is a recognition that we're interested in receiving information not only on sentences in the aggravated or mitigated range, but also when they are departures from the guidelines. So we want to make sure that we capture that in what we're asking courts to report. And then the other thing that we're suggesting that we add here is in response to what I think Judge Bernstein and others talked about, but also in response to what we initially had proposed as adjustments to the offense gravity score that would be considered upfront by, at sentencing or before sentencing to adjust the prior record score. The idea was those kind of factors, we want better information on when substantial assistance or other things like that play into the sentence. And so the suggestion was we should build into the guidelines, into the text of the guidelines, common reasons for aggravation or mitigation that we encourage courts to use those reasons or provide others so that we can get better information on why there are sentences outside of the standard range. And so this language in the box there hopes to get at that. I want to thank the Philly defenders for providing, and the public defenders generally providing really useful recommendations. Our strategic planning work group came up with a bunch of these. A number of prosecutors suggested things like substantial assistance and role in the offense and other things like that. So instead of having them as aggravated versus mitigating reasons, because we know that some reasons fall into both categories, we used what our appellate review statute considers. And the first is the nature and circumstance of the offense. So it's offense related. And the second is the history and character of the defendant, which is offender or person related. And so we provided a full list. We also included in the offender related one, the reference to assessments for alcohol and other drugs, validated assessment of risk, needs, responsivity, and also the use of problem-solving courts as reasons for aggravation or mitigation. And that final other should just be another category. But in both cases, we wanted to make sure courts could enter any other kind of reasons they thought were appropriate. But what we can do is once we build this or something like this into the guidelines, then we can build this into SGS Web. And so when it comes to sentencing, and especially for any reasons, but certainly for reasons, aggravated or mitigated reasons or departure reasons, there could be effectively check boxes to facilitate that. And it would give us much better information to analyze in terms of why judges are departing, for what reasons, and how common they are. So with that, I'm sorry for the 2-hour monologue, but that sort of is a summary of putting all the things we've talked about sort of into the text of the guidelines. Staff is working separately on a total review of the offense list. So we're not only making sure the list is complete and sort of changing the values so they line up with the values under the 30-point scale instead of the 36-point scale. But it also gives us an opportunity to look at a couple of things that we heard. One is about DUI and some other serious offenses that people had concerns that maybe the classification was off a bit. So we want to look at that more carefully. And we want to look at an issue that was raised in Philadelphia and by the Public Defenders Association and others about the really limited number of level 1 sentence recommendations. So we want to look at that sort of lower level where we have A and B, we have restorative sanctions and probation, and we want to try to identify a substantial number of cases that could be recommended to you for OGS 2 to be in level A of the guidelines, so that there'd be more of those available for consideration by courts. So with that, I'm going to turn it back to the judge. 3 minutes left, Judge, but certainly have to take any questions or sort of write down anything you want us to work on in preparation for the September meeting.
All right, so first, are there any questions or comments? All right, my last question is just, and I know we'll discuss this in September, but when you have the non-exhaustive list at 30313B, oh, excuse me, C, and it's comment BMH 71, it's discussing aggravating or mitigating. And when I read the list, first of all, I think there's some that some people will bristle at, but secondly, it looks like they're all mitigating. So I'm assuming we're going to work on this and discuss this.
Yeah, I'm happy to add, subtract, modify, do whatever. This is based on the initial list we published in January and then the comments we received during public hearings. And so if there are other factors, other circumstances or reasons that should be added or some that you think should be removed, happy to do that. This was also based, this whole thing started by looking at our annual report and the reasons reported to the commission. And, we didn't include negotiated plea, which didn't really tell us anything. And we didn't include because it's enough. But we did, we did try to include some of the other ones, such as mental health and drug and alcohol dependency, things like that.
Okay. All right. And then other than that, if there are any follow-up questions based upon that discussion. So if that is the case, then first of all, I thank you, Mark, for your presentation. I think it necessitated a monologue. It is a tremendous amount to digest. And at least for my purposes, I imagine a lot of other people, the way that you presented it and the way it's highlighted and broken down makes it much more clear. For me, I'm a visual person, so this was tremendously helpful. And on behalf of the commission, we appreciate all the work that's been put in. And so we will take some of this stuff up in September, and we'll adjourn the meeting for today.
Judge, and if I could just make one note, returning to Professor Mystic's comment, at the call of the chair, the commission may have an executive session between now and the September commission meeting to consider personnel matters. And the September meeting will include a policy meeting the day before the quarterly commission meeting. We'll be getting information to members about that. But the September meeting is in State College, and it's and I should have the date here, but it's September 7th and 8th. So that's a Wednesday and Thursday.
All right, thank you. Anything else? All right, then we really are adjourned. So we'll see everybody in September. Thank you,
everyone.